Mohan Gopal, sir, Honorable Justice J R Midha, sir, who is a distinguished professor and advisor to our law school, Ms. Aradhana Galgotia, Director of Operations, faculty colleagues, students, ladies and gentlemen. I welcome you all to this very special session on why legal education. Galgotias School of Law feels proud to state that we have organized various guest lectures and we had several guests with us, but seldom we have on our platform somebody who's a great academician, a lawyer, a jurist, a visionary, and a true stalwart in all sense. Today is such one lucky day. Today, I'm excited to introduce our speaker for this session, Professor G. Mohan Gopal, the audience first. Professor Gopal has a doctorate in law SJD as well as master's degree in law from Harvard University, USA, a bachelor's degree in law from Delhi University, as well as a bachelor's degree in science from Kerala University. Sir has held various prestigious positions in a domestic setup as well as globally. Lining them a few, Dr. Gopal was Director, Vice Chancellor of National Law School of India, University, Bangalore. Sir was a Director of the National Judicial Academy of the Supreme Court of India in 2006 to 2011. Subsequently, Sir was Founder Chair of the National Court Management System Committee of the Supreme Court of India, established by the CJI to reform and strengthen court management system of India. Sir is a former director of the Rajiv Gandhi Institute for Contemporary Studies, New Delhi. Between 2011 to 2017, Sir has been a member of various national legal and regulatory bodies in India, including the Law Commission of India, UGC, SEBI, Copyright Law Board of India, the Kerala State Planning Board, and the News Broadcasting Standard Authority, NBSA. Dr. Gopal is currently a member of the governing body of ILI and MNLU Mumbai. He has been a member of the governing bodies of various national academic institutions, including the IIAS Shimla, JNU Delhi, Nalsar, Hyderabad. And if I have to briefly state Sir's international exposure, expertise, and contribution, then Sir has served for 18 years as a chief counsel at the World Bank Legal Department in Washington, D.C. Sir has also served for 3 years as a counsel in the Office of General Counsel, Asian Development Bank, Manila. And if I talk about Sir's academic contribution to international institutions, then Dr. Gopal has taught at Georgetown University Law School, Washington, and Sir has also for more than a decade, and Sir has also taught as a lecturer at National University of Singapore in his very early career between 1980 to 1983. Currently, Sir is a member of the National Judicial Academy Council of the Supreme Court, led by the Honorable CJI, and also coordinates an informal platform on law and justice, the Center for Legal Change. So his focus of work has been on justice, theory, policies, institutions, and practices. Ladies and gentlemen, it's an absolute privilege and a great honor that we have amongst us such a revered personality who has so much to share and so much to offer from his diverse experience. And we can't thank him for agreeing to come on our. So with that, I would like to invite you to please deliver your address from the entire experience you had wearing different hats throughout these years. Welcome you, sir. Over to you, sir. Welcome, sir.
Welcome, Professor Mohan Gopal.
Thank you, ma'am. Sir, we are very eager to hear a part of your, any part of your life, which is, I think, each part of it is as inspirational as the other. So all of us participants are quite eager. You may now address us.
Yes, thank you very much.
Welcome, Professor Mohan Gopal.
Sir, thank you so much. Very nice to see you, Honorable Justice Midha. And thank you for the kind invitation, and it's wonderful to be with you. Madam Dean, thank you for the very generous introduction and the very kind words. And Priyam, thank you also for your comparing. Let me begin by you're all in law school. I was in studying for your LLB. I was both Justice Midha and I were studying for the LLB in a 3-year course in the same campus law center in Delhi. I was 6 years ahead of him. He was. I studied from. I studied from 73 to 76, and he came from 79 to 82, if I remember correctly. I wanted to ask you, sir, and I will answer that question myself also. Put yourself in the shoes of these young people. We were there. They have not been in our shoes, but we have been in their shoes. And this question, why legal education? As you look back, how would you answer that in 1 or 2 sentences? And I will answer that myself also as a beginning to our discussion. When you look back, why do you think why legal education? What is the purpose of legal education? Those 3 years that we spent.
Professor Mohan Gopal, as I see it, most important thing is to have a rational thinking, analytical thinking. We all know from our childhood how to find out the truth, what is falsehood. But difference between a lawyer and a layman is there is no rational thinking. Of course, knowledge of law in the law course, we have to give them the knowledge of law. But more important is knowledge of law with critical thinking and then communication skill. This is as I see it. So, but I think you are in a better position to put light on it because your experience and your knowledge is more diverse.
Yes. No, I agree. Sorry, please go ahead.
We look upon you, and I still remember when I had to write a judgment on what is truth and how to discover truth.
Yes.
So I requested you to give your experience and knowledge, and I compliment you, and you had given a very wide vision and a new vision to it, which I have reproduced as to what is truth and how to discover truth. And upon our elevation, we had attended the session at National Judicial Academy. So I will request you to give us a new, you can say, sphere as to what should be the legal education so that the student on completing the law course is a complete lawyer. He should not have to wait and struggle for 8 to 10 years or 15 years to just know as to how to survive and how to become a good lawyer. To my mind, we should be able to, a law graduate on completing the law degree on day 1 should be able to argue the case in the best possible manner. He should know where to file the case, how to file the case, how to have a rational thinking, and how to assist the court in doing justice.
Thank you very much, Justice. Definitely, I agree with you because we are now going back to almost half a century. For me, 76. We are 45 years after 76 now. So when I asked myself the same question, first of all, I wish I felt, I think we all felt we were not given much clarity. The answer to the question that we were told was, you are here to study law. So you study whatever your subjects are which you are asked to study, and then do some extra reading. Pick up some law reporters, just go and read law reporters. There were a few journals, but there was no internet. There was the library in Delhi Campus Law Center was already bad, and 6 years later it must have been even worse. But it was not a very good library. We didn't have access to any library. So whatever little material we had, we could not afford. My parents were civil servants; cannot afford to buy expensive books. So it was a struggle. But the answer to the question why legal education that we heard when we were students was you're here to study, study whatever you do, study well, do well. And Arun Jaitley was in my class, Raju Ramchandran was in my class, Rupinder Suri was in my class. Many of these people were, many others also who are very, like in your class also, I'm sure the Campus Law Center has produced a lot of very distinguished people. So, but somehow I felt that this cannot be simply about learning some mantras, rules, studying those mantras by heart. And then when we go into a lawyer's office, as you said, when a client comes and says, my cow was stolen, then you'll say, okay, which mantra should be used to get relief? It is like which puja to do for birthday, which puja to do for marriage, which puja to do for adoption or whatever. We have to know which mantra for that purpose. You go and repeat that mantra, and then you pray that you will get, literally pray, it says pray for relief. You will get relief. So if people have a problem, they come to you, you learn some rules, some mantras, and if you know the mantras well, then you are a good lawyer. If you can easily come up with a mantra, and you can chant that mantra before the judge, and which is relevant to the facts, and will get relief, then you're considered a good lawyer. There was nothing. So that's still, I'm afraid, I deal a lot with legal education now. Also, I go to, like just yesterday, I was speaking to over 200 students, government law colleges in Kerala here. I'm speaking from Kerala. And the topic was the idea of justice of the Constitution of India. I'm very happy to say nearly 200 students attended, and we had a very long and good discussion. So I'm interacting with students, but I find that the students are still, by and large, in our country, told the same thing, that you are here to study some rules. They may be rules of the statute, rules of the judicial precedent, and then you learn also how to interpret that mantra in a slightly different way. It's like you have a raga, and you can play with the raga a little bit within that. You can't go outside the basic framework. So how to do that? In Carnatic music, maybe in Hindustani also, which is called Sangati. These little variations that we do. Now, so a lot of the students who are listening to us are still told by society, not by you or me, that that is really your only job, to study the rules and come back and study. But in contrast, since at that time I was living in the US, and my children grew up there, so I have 2 daughters, and they're by their own choice. I never asked them. They both become lawyers. They both become lawyers and are practicing law now. And I taught also for 9 years at Georgetown Law School, and I heard this there also. The answer to why legal education in many American law schools is a very simple answer, and that answer is to get the students to exactly what you said, to get the students to think like lawyers, So when I started teaching as a young professor, I was working at the World Bank, but I was also teaching as an assistant professor for these 9 years. I was told, and I had studied before that at Harvard Law School. I was there. I did not pick it up so clearly. That was much earlier. But by the time Georgetown, I was teaching there, I was also told that, look, the purpose here is to think like a lawyer. Okay? Get students to think like a lawyer. But I saw this that this was more than a slogan. When I saw the transformation in my 2 children, after 3 years of legal education, there you do 12 years of high school, 12 years of school, then 4 years of undergraduate, and 3 years of legal education. You're doing 12 plus 4, 16 plus 3, 19 years before you get your first law degree. And both of them had also done master's degree, so they had studied longer than that. So they went to law school as very well educated and mature, not like going from 12 standards to 5-year course, but both with master's degrees and with 4-year undergraduate degrees. And yet I found that in these 3 years, they started to think differently as human beings, And so then I started to discover that this is real. Something is happening here. It had happened to me, but I had not noticed. But when it happened to my children, I noticed. So I would say, based on what you said and my own experience, if when I was in Delhi University Faculty of Law, if I'd been told your job is not to learn those rules, because the rules we learned, almost all of them. See, 73, I went there, that was Keshwanand Bharati, the year. I got to law school, the year Keshwanand Bharati was decided. Right? And after that, a lot of judgments have come. The law has changed very radically. When I applied and went into law school, it was Golaknath. Right? And then it became Keshwanand Bharati. So the rules that I studied are constantly changing and evolving. And most of those rules are irrelevant. That knowledge that I picked up in the 3 years of law school is obsolete and irrelevant. Even the styles of law practice are irrelevant. The atmosphere in court is irrelevant. There was, we used to actually, 2-3 of us, after our classes, we used to go to the Supreme Court, to the Chief Justice's court. And we used to, as students, we used to walk in, pull the door open. There was no security, nothing. We pull the door open, we go and sit there. And I've heard Palkewala argue, I've heard Krishna Iyer, and then A.N. Rai was the Chief Justice. So we would listen to all these arguments, and then we would leave. We would enjoy that, and we would leave. And it was a very different environment, different world. Today, it's a completely different kind of issues that are being litigated. Massive change in the last 30 years that I have seen globally. And all the law schools in the world, including in the United States, are in a moment of great crisis and great change. And many of them in the US are asking, do we need 3 years? Do we need only 2 years? What do we do with these 3 years? So if students are interested, they can go to the website of some of these law schools like Harvard Law School and read papers on how they're changing their curriculum. So we are in a period of great change. So clearly, yes, you have to study the rules that you're told very well, and you have to do well in your exams, and you must, get good marks, and you must do whatever you're expected to do by your teachers. But I think the point that Justice Midha made is the key point, that we have to develop a new way of thinking. That is really the core purpose of legal education. So I'd like to focus on that. I'd like to focus on that aspect. What does this mean, really? Justice Midha mentioned rational thinking and analytical thinking. That's very, very important. But so I'm going to talk a little bit about this, and after that, you should think yourself. But please understand that the main purpose, when you read the rules of precedent and statute and all that, you have to be mindful. The Buddhists call it mindfulness. You have to be mindful about how you're thinking about it, and see how you think about it when you enter law school, and how you're thinking of it in law school. How is your teacher thinking about it? How is Justice Midha thinking about it? How am I thinking about it? And then how we can, and how should we be thinking about it? So let's start thinking about thinking like a lawyer in a very briefly at the beginning of society, at the root of society. And the root of society, I feel there is a constant struggle in all societies all over the world between two modes of thinking. And there is also a combination of these two modes of thinking. And both modes are applicable to law. But there are two modes of thinking. One mode of thinking is obedience. Obedience. So we upload information to our mind, that is pre-cooked information. We upload it into our mind, and we learn it by heart, or we know how to find it, and we make sure that those whatever is uploaded in our mind is obeyed and followed and protected and preserved without change. This is one way to think, that our job is to obey, absorb whatever we are, including obeying the content of what we are supposed to absorb. And in this model, the more obedient you are, the better you'll be rewarded. The other model is a model of questioning. It's the opposite of obedience. It's a model of questioning, where whatever you're told, you question. Whatever you're told. There are no, I'm using this as a phrase in English, I don't mean it literally, but there are no sacred cows. There are no sacred cows. You question everything, right? Anything that is told to you, including thoughts that come to your mind, you question. Right? So Einstein said that questioning is the central purpose, actually, of he didn't use those words, but he basically said, never stop questioning, never stop questioning. It's the very purpose of life. Now, the consequence of these two options are, if you take the first option, that the method of thinking must be primarily to upload, absorb, upload, repeat, obey, then you will have a very conservative society that doesn't change in any way. Or there will be change that will be very, very, and that's how we approach classical music, for example. Right? We can't change the fundamentals, but we can make slight changes. We can use one little instrument, and and so on and so forth. So it will basically ensure that our society remains a classical society. Classical is a synonym for old. Classical music is old music, not contemporary music. I remember asking a wonderful tribal musician once what's the difference between classical music and folk music. He said to me, हमारे लिए बोलना ही संगीत है और हिलना ही नृत्य है. So all speech is music and all movement is dance. Right? So there is no judgment, there is no structure. You move, like, the spirit of nature. I found it a very, very deep and profound understanding. So if you take the obedience model, you will end up with a conservative society. The advantage of that is everything will be predictable. Nothing will change. I will live like my great-grandfather lived, and there will be very minimum change, fighting change, only making changes as necessary. Right. The other model of questioning as a way of thinking is a model which will produce very big change, very unpredictable change, and we don't know where things are going to go. Change is, as the common saying, change is the only constant. The Buddha said that you do not step into the same river twice. We don't realize it at my age, 6 years older than Justice Midha, but he may also start to realize that we are changing, our body is changing in ways that we are not aware of. We think we are still 40 or 45 or 30 or 35, but actually we have changed very radically. But the change happens very softly, like drops of water change the shape of a rock. A hammer cannot change it, but drops of water gently falling on that rock can reshape the biggest rock in the world. That's how change is happening. So if we accept the truth that the world is changing, everything is changing, and we question the past and the present and the change, and we understand the process of change and try to align our lives with the process of change, then I think we may actually have a much more interesting life than if we are trying to do the impossible, which is to fight change, because we cannot fight change. We cannot fight change. So therefore, in the second model, we have to have an approach that will emphasize constant questioning. Now, in both these models, you can think like a lawyer. You can think like a lawyer in both these models. So, for example, in the first model, if you're going to have a very, the purpose is to be, the purpose of legal education, why legal education would be that you learn how to discover precedent, how to follow precedent, how to make sure that the precedents are protected and preserved, how traditions, we continue to call judges my lord, although the ships of the British have sailed a long time ago. We wear the same costumes, we call them my lord. We have very hierarchical society. We don't believe in equality, and we maintain the old hierarchical society, and we can learn that how do these conservative lawyers think. We can learn that. We can learn how to make sure that the legal system doesn't change and the law is used to fight change. So there, what the challenge to think like a lawyer is to think again in a way that is rational and analytical, but the purpose will be to conserve. But in the second model, we have to think like a lawyer, also rationally and analytically, but there are some new elements of thinking that are necessary. So then we get a little bit into the common ground that Justice Midha mentioned, rationality and rational and analytical. What is reasoning? What is reasoning itself? What is thinking? We are talking of thinking. What is a thought, right? So a thought, these are questions that you should find answers to yourself. But a thought is at some point of time when we become conscious of something that is going on in our mind, then it becomes a thought. It's something we are conscious of, we are aware of. Otherwise, we say it's subconscious. There are subconscious thoughts, but we are able to articulate. We are able to articulate only thoughts that rise to our consciousness. So a thought is basically a mental process, some kind of biochemical process that is going on in our mind, in our brain. But at some point, we start to become aware of some cognitive. It takes a cognitive shape, of which our mind can be aware, and that's when we roughly say. Thought comes from the word thein, T-H-E-I-N, which means basically to see. So something that you can see, you can be aware of in your mind. That's a thought. And the interesting thing is that thought then, if you have to articulate a thought, like I'm now doing. I have some thoughts, I'm articulating them. You have to use words. You have to use words. Now, a word is the most important single most important tool for a lawyer. The word. It is the be all and end all of the legal profession, because you have only the word to work with, to communicate, to change, to influence decisions, to get decisions, to make decisions. And the beautiful thing about the word is that vocabulary, a system of words, has its own meaning, So the moment my thought is put as a word, right, like the word thought or the word put or the word like, then it starts to have a meaning which is a social meaning rather than the thought that was in my mind, because the word thought has a meaning in the dictionary, like has a meaning in the dictionary, right? And so the moment I convert my thought into a word, I actually entered some kind of public domain. And I'm then within a community of people who understand that word, they speak that language or understand it the same way I understand. So speaking becomes thinking, using words puts us on a common platform with some communities of people. Words are also changing, dictionaries are changing, vocabularies are changing as a result of this interaction. So we have some kind of processes in our head that we become aware of. We put it into words, and then we use words in a way that they are related to each other. The word logical comes from the word logos. Logos also means the word. So when you say you have to be logical, it basically means you have to use words. And the inherent characteristic of a word is that you can only understand words in relation to other words. You can't understand words in isolation. You have to understand there is a combination of syllables that produces a word. So it's a relationship between syllables. It's a relationship between words. So logical means that it is a system, a pattern of words. Now, if I say blue and then water and then velvet, right? I'm using three words which have no connection to each other. Even when I say them, I have no connection. Then I can't say it's logical because these words are not connected to each other. It's the relationship between these words that we mean logical. So therefore, when in both these approaches as lawyers, the thinking like a lawyer, the first quality of thinking like a lawyer is to be very precise with the use of words. See how many times I've told you the etymology of every word I'm using. So you must always have a dictionary, an etymological dictionary, and every word. A surgeon can be loose with the word, but not with his knife. A lawyer can be loose with your knife when you cut fruits, but you cannot be loose with your words. So every word, so how you convert a set of sensory inputs come into your mind. There's, cognitive experts say that basically what happens in the brain is we get sensory inputs, it interacts with our memory, and then some cognition arises in our head. And when those cognitions are first converted into words, we have to be very careful about what words are coming to our mind. We can't be neutral about it as lawyers. So I see something and I say, oh, terrible. Then I say, oh, terrible means something that will cause terror. But I can't say it is not causing terror. It's very sad. So I can't say terrible. I have to say tragic or very sad. So even at the very cognitive process of converting my thoughts into words, I have to be very precise about what is going on in my head. What words am I accepting or adopting to give body to the cognitive processes that are going on in my head. And then at the next stage, when I want to communicate it verbally or in writing, I have also got to be very precise. This is very, very important because the fundamental building block in law is a fact. The legal system modern legal system works on facts. As you know, a fact is defined as a thing or a state of thing or a relation of things which is capable of being perceived by the senses. Right? Or a mental condition of which someone is conscious. Right? So here we are talking of words or cognitive processes that can be converted into words and how these words relate to each other. So a fact, a proof of a fact, and we discussed about what is truth. Ultimately, truth is a fact that is proved in accordance with the evidence. That's law's truth. It's not God's truth. It's not man's truth. It's God's truth. And because we don't know what God's truth is and man's truth is very unreliable, therefore we go by law's truth, which is the truth established through the procedure prescribed in the Evidence Act. But once a fact is proven, then the existence, non-existence, nature or extent of right, liability or disability, which is a definition of a fact and issue in the Evidence Act, arises only from the connection between these facts. And facts also ultimately exist only in words, not in physical reality in the law. Because they have to, a human being has to describe them. That has to be transcribed by a court as evidence. So the entire process of law is a game of words and the relationship of words. And it is a relationship of these words that produces actually the result of existence, non-existence, nature or extent of right, liability or disability. So the first thing I realized when I was interacting with my daughters is that their ability to be precise in their speaking, thinking, dramatically changed. And I also found that whatever, because I've been a lawyer and I'd unconsciously developed these habits, very often I would have, when they were little children, I'd say, please speak clearly. Tell me what exactly do you want? You know, what are we talking about here? Right? That was because I was thinking like a lawyer. And sometimes they would get exasperated with me. Come on, you know, what is it? I've said it. You understand if you want to understand, right? But once they went through law school, that kind of communication problem between us disappeared. Because they are speaking precisely, I'm speaking precisely, and now it's a very good communication between all of us, because we are all striving to speak more and more precisely. So law is a science of precise thinking, very precise thinking, where the content of words matter and the relationship between words matter. Because in the law, in order to ensure that the law operates objectively and not subjectively, all reality exists only in words in law, in the mind of the law. Everything exists, the world exists only in law, only in words. Because words are, as I said earlier, an accepted medium of recording thinking. So when you have an accepted medium of recording thinking, and you insist that everybody's understanding of reality is reduced to writing, then we have a common ground to proceed. And so the physical reality gets converted to a verbal reality. Reasoning is a process, a method of thinking, is a method of structured thinking. A particular method, reasoning can be scientific reasoning, it can be legal reasoning, and I'll come to that. And rationality is the purpose of thinking. Why do we think? Analytical can be in law, it can be in science. It's simply, again, a framework of thinking. Analysis is only a framework of thinking. So what we have said so far is that I've said broadly there are two ways we understand that legal education is really meant to give us a new way of thinking. And all this we are studying, case laws, precedents, statutes, is actually supposed to make us think in a different way. But I said at the big picture, there are two options. We can either question or we can obey. And I'll come back to that. But in either case, we have to be very precise. We have to be very precise. And we have to be very precise, and we have to apply that precision scientifically. And this is the second point in it, on which precision depends a lot. We can only do evidence-based thinking. So I have great difficulty when, recently a Kerala High Court judge said, okay, in his judgment, that God will be with us, because the issue was, should a temple be demolished to build a road? And he basically said, yes, there was, I think, a temple and a mosque, both had to be demolished. He said, fine, demolish both of them. Then he said, but that, God will be with us because God wants people to develop and progress. And also by demolishing a temple, God is not going to be upset. But see, God is not perceptible by the senses, perceivable by the senses. And therefore, a court cannot take cognizance, or the law does not take cognizance of anything for which there is no empirical evidence, evidence-based thinking, like science. Please remember that in the long years past, law used to be basically a part of religion, theology. Now law has become part of science, basically. And we are adopting all these methods of thinking are scientific, logical, evidence-based. So, as I said, fact-based. The relationship between facts expressed only through a particular system of words. And those words are words of general meaning, and those words are words of specific, special meaning, which is only in the legal system. And we have to master those meanings, both general and special, and the relationship between words. And we have to make sure that these words only are used to refer to what is proven through evidence. So we cannot accept superstition. We cannot accept faith. We can accept faith as a fact that you have this faith, but we cannot create right, liability, or disability based on faith. Right, liability, or disability must come from law. And I'll come to the next step in that. Law is basically a set of hypothetical facts. It's just a fact pattern. And so law also can only deal with facts, cannot deal with faith or superstition. And so rights, liabilities, and disabilities are arising from facts in issue and relevant facts. And therefore we have this scientific approach to think about something, right? Either from a obedience point of view or from a questioning point of view. But think about something. When we think about something, we must do so precisely. It must be fact-based. Truth must be based on evidence. Man's truth based on evidence. We cannot accept what is not true. The relationships must be logical. They must follow structured reasoning. Now, where do you get the structure of reasoning? The Evidence Act is a system of legal reasoning. The Evidence Act is a system of thinking, is a system of legal thinking. How do you think? How do you come to a conclusion that a fact is proved? That's a mental process, and you have to follow the mental processes prescribed in the Evidence Act. Similarly, many procedural laws require us to think in particular ways. If you read a very wonderful Law Commission report written by Justice Gajendra Gadkar on evidence law, Evidence Act, it's a brilliant Law Commission, old report. He says there that the Evidence Act is pointed against the mind of the judge to make sure that the judge acts objectively and not subjectively. So why legal education? To think like a lawyer. Why think like a lawyer? Because we do not want subjectivity, we want objectivity. We don't want to be ruled by individuals. We want to be ruled by facts, proven facts, and the law. And the lawyer and the judge becomes really gatekeepers or minders or shepherds through this method of thinking, which is logical and objective. Objective, the word objective comes from ob and yective. Ob means a thing. Yective means thrown in front of you. External. Ob is external. So which means objective thinking has to be based on facts which are outside you. You cannot rely on anything inside. Subjective means something that is under your control. The yective means something that is thrown, but it is under your control. Subordination, under your control. So you cannot make a legal analysis or legal decision based on something that is under your control. You have to come to a legal conclusion based on things that are not under your control, which are objective, which are objects, which are out there. So when you connect those objects together as described by words, then you get a legal result. So when you assemble all the facts talk to each other and you'll get a result. And that's an objective result based on objects and not based on subjectivity. So therefore, in order to develop, as we read these cases, as we go through legal education, we must question, are the judges being objective or subjective? So when you read a judgment where the judge refers to God, you'd say, well, that's not a legal way of thinking. Doesn't matter if a court does it, court has said it. You say that's not legal, because legal thinking has to be objective, based on facts, proved facts. It has to be built on approved connections between facts, approved connections between facts. So sometimes you may need a fact of intent, which is evidenced by a certain set of actions in order to get liability. Where there's strict liability, there is no need of a relationship of intent to connect the act to an intent in order to get liability. So the relationships are prescribed and must be established in that prescribed manner to lead to a result. So precise thinking that is very aware of the connections, which is what we mean by logical, of the manner in which the thinking, the elements of thinking are connected to each other. They must be based on facts, and they must be rational in the sense they must lead us to the conclusion of the exercise that we are undertaking. Now, I'll say a little more and then we can have a discussion. And the question is, why are we doing this? So thinking is a how, right? We want to do legal thinking. It's a how. And so the first point I'm making too is there's a difference between legal thinking and legal reasoning and the thinking and reasoning of those who are non-lawyers. And I've given you the elements of that. One is it's all word-based, not based on emotions, not based on superstitions, it's based on facts. It is based on words. It is based on patterns of relationships between facts as expressed in words, which are approved, which are legit, which have come from approved by law, established in law. The other aspect of a difference between a legal argument and a non-legal argument is that every legal argument has to be based on a legal principle. One important difference between an administrative proceeding and a legal judicial proceeding is that an administrative proceeding can, within the power given to an administrator, be based on expediency or policy. A judicial proceeding can only be based on law, cannot be based on expediency, cannot be based on convenience or policy. It has to be based on legal principles. So the legal reasoning is we take facts, we take legal principles, and I'll come in a minute to what legal principles are, and we combine facts and legal principles with great precision, and then we get a result that emerges from these relationships. Now, I've told you that a law, and I want to go a little more into this, I've told you that a law is a hypothetical fact pattern. Hypothetical fact pattern, right? So what is murder? It's a hypothetical fact pattern that someone with an intent to kill does an act which results in the death of the person that he intended to kill. So then it's murder. It's a hypothetical fact pattern. There's a pattern there. Pattern is a very important word. It's a pattern of facts. Where there must be an intent must be linked to the act must be linked to the object of the act, a person, and the person must die. So there is a pattern that is required. When an actual event occurs, if that fact pattern matches with the hypothetical fact pattern, then liability necessarily follows. The words of the Evidence Act necessarily follows. So there is a mathematical precision in this thinking, actually. Mathematics is also a science of patterns. It is not arithmetic. Mathematics is a science of making patterns and finding patterns. So law has a very mathematical quality to it, namely it finds patterns. And thinking like a lawyer is about searching for patterns based on facts, based on principles, finding these patterns. And from those patterns emerge legal liability, not from my subjective sense of this is right, that is wrong, and therefore liability must follow. Right? Okay, now the second and the last part is, this kind of thing can be done in Hitler's court, right? In anybody's court, and so then we suddenly say that the rationality, Justice Midha talked about rationality. Why are we doing this? What is the purpose of law? There is a method of thinking, but why are we applying this? So there are Hitler's doctors who did experiments on Jewish people to torture them to see how much of pain they will suffer, how to kill people. They were also doctors. But they were doing experiments not to save life, but to kill people. But they were using the same techniques. So therefore, because of the power of this way of thinking, of precise thinking, of translating what is going on in the world in our cognitive head into words, establishing patterns in those words and convincing people to obey those patterns. When people obey the law, they're just obeying patterns in words. Great power. It's almost like hypnosis. But this must be used for a good purpose. That's where the Constitution comes in. The Constitution gives us the purpose of legal thinking and legal work. And the Constitution of India, not all constitutions, basically tells us that ultimately all legal thinking must promote justice. Article 39A says that the state shall ensure that the operation of the legal system promotes justice on the basis of equal opportunity. So we think like lawyers, but we use that skill in order to promote justice. So very briefly, sir, how much time do I have, sir? When do I have to, roughly when would I stop, sir? Justice Midha or Priyam?
Sir, you definitely have another 10-15 minutes.
Okay. Let me say take 10 minutes and then we should have a little, any possibility of a discussion?
Yes. So we'll have 20 minutes for discussion.
Okay, great. Okay, so what I've told you so far is why legal education in order to think like a lawyer. I've described that to you. But why do you, what is the purpose to which, why should you be thinking like a lawyer? And the answer is to promote justice, Because I tried to give you a glimpse. It's actually very complex, not complex, very detailed. Nothing is complex, but very detailed issues that I've talked about what is legal thinking. But I've told you it's basically precise thinking, it's logical thinking, it's fact-based and evidence-based thinking. It is thinking that searches for patterns and checks for conformity of patterns with required patterns. And above all, if there's one quality, it is precision in logic and precision in following structures of thinking and precision in terms of the content of meaning. That is ultimately what thinking like a lawyer actually means. Now I come to the last part, which is why are we thinking like a lawyer? And I said the answer is given to us by the Constitution. It is to promote justice. But then the question is, what is justice? Again, because I have to think like a lawyer, and I hope you will also do the same. We have to break down the word justice and understand it. The word justice. Because I have some feeling in my mind, right? When someone treats me the wrong way, even little children, if you take a chocolate and break it into two unequal halves and you give it to a tiny bit to one kid and big chunk to another kid, the kid who gets a small bit is going to get pretty angry, right? So there's a feeling. Justice is a feeling. Injustice is a feeling, or but when we talk of justice as lawyers, we can't talk in that way about feelings. We can't talk like that, because I've already told you that's not thinking like a lawyer. We have to be very precise. We have to know what we mean. That is thinking like a lawyer. So how do we understand what is justice? And the first thing is to understand the word, because the moment we take that feeling and pour it into the word called justice, it acquires the meaning of that word in context. So what does that word mean? The root of the word justice is J-U-S, use. That is also the root of the word judge. It is use plus D-E-C-I-R-E, decere. The root of the word justice is J-U-S, and the other limb of this word is S-T-I-C-E. This is my own analysis, but I have some connection, some support for it, academic support for it. I'm not getting into that, but it's easy to understand it as a combination of two words. There are other ways to understand it as well. They look at it as justitia, justitium. It's all pretty much the same thing, but I think it's easier for us to understand if you understand. Everyone agrees that the root is J-U-S, and what J-U-S means, the right value, the right norm. So that's why I say, give me just half a cup of coffee. And I can also tell Justice Midha, sir, your judgment was just. Just half a cup of coffee and just judgment. What does it mean? It means half a cup is the right norm for the amount of coffee I want. And the judgment is just because it meets the required norms of rightness of a judgment. Therefore, it is just. So JUS simply means the right norm or the right value. And just means something that meets the right value. Justice is really those values that stis means stand forever. Sthai is the same root, actually. In Proto-Indo-European, it's the same root. Stis and sthai, sthit or sthai, right? So sthai use uses the norms that the standard of right conduct, that is use, standard of right conduct. That is sthai, is justice. So you could say that justice is an eternal set of eternal values of right conduct. That is what the word actually means. So when the Constitution says to secure to ourselves justice, social, economic, and political, it means to ensure that we have a society where social, economic, and political relations are governed by the right values. Right, not just for today or tomorrow, like wearing a mask is right for today. I'm alone, so I'm not wearing a mask. But it is a right standard for today because we have COVID. But once we get rid of COVID, then it's no longer wearing a mask may be rude, it may be unnecessary, it may be silly. But to be not spread disease to anyone, that's an eternal value. Today it may require wearing a mask, tomorrow it may mean not wearing a mask. But that's an eternal value, that we as human beings should not spread infection or disease. So justice refers to the second type of values, which are long lasting, which are eternal, which stand forever, sthai. Okay, so within the very short time available, I have another 5 minutes. Justice means a set of eternal values, sthai values, right values. So we know that when 39A tells us that the operation of the legal system includes all of us, not just courts. All of us, everyone in the legal profession and the legal system, our job according to the Constitution is to promote justice. That means promote the right values of conduct. And justice crystallizes or is realized only when actual human conduct is in accordance with these values. Until then, there is no justice. We may take steps towards justice, like issuing a judgment or making a decision. That is not justice. Justice is not a description of a judicial process. We did not make this republic in order to have good judgments from our courts. No. The first objective of the Republic is justice, social, economic, and political. It simply means we want a society where social, economic, and political relationships are in accordance with the right values, the sthayi use. So we have to promote the right values. Now, what are the right values that that we have to promote? As far as the Constitution is concerned, each of us is entitled to have our own views about what is right, what are the right values, permanent right values, eternal values, and what are not. That's up to us. But the Constitution says that the right values are essentially what are in the preamble, and they consist at the core minimum of 4 standards of human conduct.